You said that your petition is couched in a way that it is akin to Mr. Prabodh's case.
Let's see only.
He was arguing that. So that was unblocking of portal registration with withdrawal of decision or quashing of that decision of blacklisting coupled with debarment. So it was his case. And your case, you said that it is akin to that. But while dictating that judgment after that, I found that you have prayed for declaring the amended provision under clause 3.5.5.
OPWD code as well.
So that as
You abandon.
I will abandon. If
if that prayer is there, it is difficult to say that it is akin to that. That is what I am saying. You-
For that reason it has. Put it for orders.
So you are against blacklisting.
Blacklisting will stay lordship. Only regarding portal blocking lordship.
Portal block.
They are lordship. That is lifetime of the contractor's lordship. If
Yes, that we understand. Debarment or a blacklisting has a very cascading effect. Don't worry.
So that's where I got confused that since you prayed for this and on that line also they have not come forward.
That could have been lordship.
That-
Sorry.
Call the two. I'll send it and
Oh, yeah, okay.
one line order that the matter was again listed today.
No, sir, but-
For
Cases related to that lordship challenging validity.
Accounting principle.
Lordship. That provision.
I'll take your lordship to the interesting points involved here. Previous order and I'll take your only two interesting points involved here and.
Mr. Rath,
I humbly request my esteemed seniors and I also pray for your lordship Miller. One opportunity may be given to the state.
Unless we give him time and again, lordship, for indefinite period lordship, they have stalled the entire democracy.
see, the last,
Lordship,
Only
on the last
chance
occasion,
will be given to us.
government advocate himself has taken some time.
That is may I just.
I think
provision is very.
that's
Only one chance may be given.
lordship, we have not seen. The
Your lordships consider it.
no. You should be considerate for.
That's what I'm saying, subject to what your lordships consider on their prayer.
The impediments, the hurdles, or the obstructions. What more expression I don't know I can use for them.
Lordship, but all that.
My lords, may I suggest something? Your lordship fixes a date for hearing this matter. Within that time, let them file a counter, giving us enough time to file a rejoinder if any. Lordships.
I think Mr. Tamango will appreciate this. But I pray on behalf of all these.
Till that date, just to supplement both my friend, till that date, if the bills be routed through us to the summit, whatever bills are passed,
My lords, we are elected members, my lords.
we routed through us because the reason for this.
I was reading paragraph I think 5 and 6 of my last
Lordship.
judgment,
Yes, sir.
order.
Order, Lordship.
And it is really very alarming.
Alarming. Entire committee democratic setup is taken over by the executive. And that to who? A person who is subordinate to the chairman and committee. If a lordship only looks at two provisions in the statute, section 19 and 20, the kindly see lord, section 19 and 20. Of course, they are still not-
We understand.
But can it be tomorrow for this limited purpose?
Don't sus.
But
I was there.
I humbly apologize. I humbly apologize.
Going
I-
merrily after argument and then creating.
I humbly apologize.
Well, both your lordships were here.
That's your lordship, Lord. The subject of your lordship convenience. But then, Lord, our anxiety is.
These are the matters which require a deep scrutiny. We require a churning of the many
Yes, Lord.
constitutional provisions as well as ethical provisions.
But
And it may not be done in open session.
I'll only submit one sentence, with one sentence. In panchayats throughout the state, there is no work which is above 10. Every work is beyond 10. And today, every elected body indirectly by way of amendment of the rules is superseded by the BDOs. That's the point. Every day they are passing bills, every day they are passing payment, making payment of 10 lakhs without consulting committee, without consulting elected body, without every day.
Not only that, my lord, the accountability lies with the body. Elected body is accountable to the electorate. And the government has the power to suspend us on allegation that there is malfeasance, there is bad faith, there is mal supervision of the work.
Every
And
day,
then
sir.
if bills are passed by somebody else, the power has been exercised without any accountability. We are accountable to the government,
The
to the
bills-
public.
The bills don't even come to us.
We don't
It
see
goes-
what's happening.
It goes to them and they pass it.
And Lordship, only 90 Lordship, 90 Lordship kindly see like
I have recorded a dedicated chapter on
Yes.
institution
Not-
provided for Panchayati Raj.
My lord,
What
not
is the
only that,
purpose
under
of
that rule,
Panchayati Raj? One has to understand why it was introduced into the constitution, what was the object and the purpose of introduction. All these things, there is no such autonomy which is given. Then
Yes.
what will happen?
We don't want to stop them from
and
payment.
rule 90,
You
subject
you can have a supervision.
Yes.
Understand.
We don't want to stop them from payment.
or
Do it through proper process, that's all.
Well, they are the elected like you. They are
Can,
the elected
can I bring one
then-
rule to your lordship notice, my lords? One rule, rule 90.
Digression.
Maybe the petitioner is praying for the
Why?
Let me see paragraph.
How the writ lines? How the writ lines?
Yes, madam. They are without taking the permission from the Kotak municipal.
I think is a G category clause. This is what I. Sir, how can you? These are all the residential housing.
That I have to take it further. No commercial available is there.
Housing sorry, the housing state where the commercial activities without the conversion or the pollution is not allowed. How can you allow a part of the property to be used for commercial?
No, that for say permission to be granted from the CMC only. CMC
I understand. Had it been a case of letting out for housing purposes, you are the owner, you are free to let out, there is no difficulty.
Well,
Unless there is a clear prohibition in your allotment. If there is a prohibition in the allotment, then you can't. But you have to seek permission. If it is not, the owner is entitled to do whatever. You can do in accordance with law.
there is a prohibition regarding commercial. There is a prohibition regarding commercial use, my lord.
Yeah.
After that, they have not approached us, my lord, regarding the any permission. That is the main issue, my lord.
So then if somebody makes an illegal construction,
My lord.
is it not your duty to take an immediate step?
My lord, that part already shifted to my lord CMC. For that reason, my lord, I am praying that
You will
for
have a
the
notice of the CMC.
municipal permission from the CMC.
Notice on the Katak, who appears?
Devashish Naik.
I have already solved that.
You
I am independent, just now solving another problem.
you are appealing for participation.
So what structures you have? So there are rampant illegal constructions which are coming up. Are you not taking any steps? Are you not keeping a surveillance?
Millard, in
You give the
2018,
municipal law to do it.
Millard, in 2018, Millard, such an incident happened. One tower crashed. Millard.
No, the vibration which first, so the walls are.
Yes, it is very
closed.
serious.
There's no gas, madam.
And
No gas in the building.
as I said, walls made, so for this part, for the installation made in particular plot, that may affect other
Other
plot
surrounding.
owners also who have residential houses.
Cracks are seen, man. Already seen cracks, man. The other plots, man.
Let us see, we are not experts.
Right.
So
This is what, before any further construction is allowed, I think the structural engineer must have gone there. The structural stability has to be ensured. Whether it can cater a further load or it cannot cater a further load. All these things the municipality has to take care of that. And if these kind of illegal constructions are coming, then sir, what you are put in place? There are a lot of judgments which has come up. One of the very renowned judgment and celebrated judgment is the Deepak Mukherjee's case of the Supreme Court. Read paragraph 1, 2, and 3 of that judgment. Supreme Court has taken note of these mushrooming of these illegal constructions across the, I think, these metropolitan cities. And have come very heavily that the authorities cannot sit tight over the map. Read that judgment.
CMC has issued a letter to the petitioner that they have not issued any permission. Why
Then how, then is it not your duty to demolish? I do not know here the municipal law, but I know the municipal laws of another state. Where the power is given to the municipal corporation that if in the event any construction is done without the permission, it's a duty of the corporation to demolish it. Will you not take that step? Impliedly, they get a sanction of this illegal construction. That is not permissible. And not expected from the municipal corporation. What?
Only for 2 weeks time it can be granted.
State face will not do. These are responsibility. When
2 weeks time.
So this letter you added to the 7/8/2025, you have said that it is to inform you that
Just now this
no
is
such permission has been accorded by the CMC authority for construction of mobile tower on the rooftop of so and so plot.
who's star? You don't know. The tower is installed.
Airtel company.
So will you not include them a party?
I will include it. I will make message.
But there was an Indus Tower Limited, I think that was. Indus Tower Limited.
Indus Tower.
Permission granted in his.
So they have to give them a party also.
Yes, but I will do it.
The
Adjourn to 23rd December.
Construction work going on that roof.
Item 4.
You should notice on the owner as well. Owner is.
Opposite party number 5.
High Court.
No, not issue. The same way he will serve the property. Whatever.
Both neighbors.
Yes, ma'am.
Yes, and I. Both.
Yes. Could you please?
Item 4.
I took for my petitioners, the branch is that the opposite part of road is constructing an franchise office over the
Should be constructed over the Gojar land.
No, Gojar
Gojar land.
It is just land for only for grazing of cows. They constructed.
Sir, I do not know your, I may be wrong in,
Page 2.
I may be wrong in understanding the English language. Please come to page 7 of your writ petition. We have said that the honorable court may graciously be pleased to admit the writ petition, call for the record, and issue notice to the opposite party to show cause as to why the Amandapur Panchayat office shall not be constructed over the Gochar land.
That is
So that is what I just thought, that you wanted a construction
No.
over the Gochar land.
No, so that shall be constructed, not to be omitted. That is a typographical mistake. I don't comment.
Shall, then it is all mandatory.
Why the land will be constructed?
It will be shall and not vote to be deleted, and will not be after the B.
That will just be copy paste.
Anyhow, whatever.
Yes,
That's a non-application of mine. That means that you have not applied your mind in drafting the petition. If it is a copy paste, then what is the, why you are constructing over the Gochar land? You know the Gochar
I have
land,
applied
unless
instruction.
converted.
I have obtained instruction in this matter, Milord. There is sufficient Gochar land available in that village. Out
So
of-
have you asked for a conversion?
Yes, Milord, stop.
Conversion allowed?
Yes.
Then what to do? That is permissible in law. How many cattle the villagers have?
My lord, 1,000.
Cattle. And how many villagers are there?
I have stated in parliament.
How many villagers are there? I understand cattle are thousands in number. Villagers in number?
My lord, that the Andhra Panchayat consists 3
I am
villages.
asking. Let me understand that each villager is having how many cattle?
1,420 villages. 1,420 villages.
So 1,400 persons are having 1,000 cattle. Has it been converted?
Yes.
Should I record? Because the language is very dicey. It is only the recommendation to convert. Has it been converted? The reservation proposal. But has it been?
The last line here, the Anandpur is D reserved. Last.
Sir, you have to read in conjunction. You said that as there is a surplus Gochar land in the said village, hence the suit land is recommended by the collector boards and approve the reservation proposal. I do not know, the English is not correct. It appears that recommendation is already there, approval has also come, but you'll have to initiate a proceeding for dereservation. Have you done it? It has been dereserved. We will record your submission that it has already been dereserved.
Millet, I will file an affidavit. I have to bring that the conversion case statement. Language is of properly worded.
Then by this weekend. By this weekend.
Yes, yes, ma'am. That is.
So you should intimate them that, yes, your language is, but is it been dereserved? The construction has commenced.
Approval is to be given by the Panchayat Raj Department. Last paragraph,
No.
alienation in favor of Panchayat Raj.
May,
By
may I pray one thing, Millet?
The
Let
revenue
it be.
revenue and disaster.
May I pray one thing, Millet? Let me pass over, Millet. In the meantime, I will open instruction.
the electric.
Yes.
If it is already dereserved, then yes. Nothing. Then you challenge that particular proceeding. Passover is coming with the.
What is the that
Item 5.
Just go and find out.
Fine.
And you, just one line, it has already been dereserved.
Item 5 is similar to item 2.
Yes.
Item 5 is same as the item 2 and adjourned to 6 January. Item 6.
If I may please your lordship.
Second order litigation of some of the petitioners below. Earlier, there was an order of this honorable court at annexure 3, page 47. Relevant page 46.
Yes.
My lord, sir. The order 1, the petitioner's representation annexure 1 shall be examined by the Tahsildar Belgaum, and after notice to the petitioners and opposite parties number 5 to
No,
20.
it's true that
Yes.
they have to hear out and give a reason order.
Indeed, your lordship. My lord, subsequently, in pursuance to your lordship's order, my
What
lord,
is
a
that?
team was constituted. Annexure 4, page 47. They complied with the order, and page 48, they form a committee to go and inquire into the illegal encroachments.
Yes.
So that is page 48, annexure 5. Then your lordship may kindly have annexure 1, page 40.
Page?
Page 14.
Yes.
My lord would see the order date 24/4/2024. My lord, the relevant part, page 15, the directions issued to ascertain the fact. My lord, sir.
The technical team is formed, he will
Yes.
make an inquiry as to the content. Yes.
Yes, the revenue inspector Binka submitted his report on this. On perusal of enquiry report, it reveals that the opposite parties, along with others, annexure A, have encroached the government land in
Maybe then, yes.
Yes. And accordingly, my lord, they had the next last paragraph, your lordship will see that the revenue inspector has been directed to proceed under the OPLE Act,
Correct.
and within a period of 30 days, the entire action of the OPLE shall be completed in 90 days.
Okay.
Very rightly, my lord. My lord, the date your lordships have seen, 24/4/2024. My lord, this order, instead of complying with this order, once again, my lord, your lordship will kindly have page 68, annexure 8 series.
Yes.
My lord,
That's the
once
map.
again, sorry, my lord,
That's the map.
page 68, annexure 8 series.
The 62. Three written in such a form. Whereas.
My apologies, your lord.
Yes.
My lord, once again, another team is constituted for re-identification of the encroached area. Instead of complying, once again, your lordship on 22/125, page 69, your lordship will see.
Within a span of 7 months.
Malab, sir, now everything is done, encroachment is removed, Malab, I have handing over the encroachment, except one person who has filed an appeal, and because of that appeal, one person is not.
Is there any stay in the appeal?
Yes, Malab, in that matter, there is a stay, Malab. Except that, everybody else has been removed, and the status report is also enclosed, Malab.
So, may I have a copy of the instructions so that I can verify your lordships?
What verify?
My learned friend submits that, my lord, in earlier occasion also on the contempt application, they had filed the affidavit stating that it has been complied with, but it had not been done, your lordship.
Revenue
Oh,
inspectors.
yes.
In the revenue inspector's report, my lord, the present status shows vacant land, my lord. Third
But I don't
page.
dispute that, my lord, if my learned friend is making that submission, but my lord, I must be, again, be given one opportunity to verify your lordships. As your lordship.
And it's the second page is the revenue inspector's report. Third page onwards is a chart, my lords, which shows the present status. Vacant land, my lords. Except one person, Jyoti Ranjan Patnaik, who has filed an appeal.
And the appellate authority has a stay.
Yes, we have just received that order, my lord, where no coercive action has to be taken against that because the appeal is pending.
A writ petition?
Not a writ petition, my lords. It's before the sub-collector, they have approached for an appeal. In that, they have, the sub-collector is directed not to take any coercive action till the appeal is finally decided.
My lord,
I have a copy, my lords.
my lord, may I just submit one thing with your lordship? It's 69 is a lordship can have. So this, my lord has written only about 6 citizens. There is one more letter for the reconstitution 22-125. So if your lordships can sign the rules, grateful.
Item 7.
Because Sarpanch has filed the PA, paragraph 1.
Sir, to the maintainability, we have held against this. We have said the Sarpanch is not competent to fight the PA. Then I have to go through that judgment. Well,
Rosalie,
we read the judgment.
well,
What to do tomorrow?
may I check the lordship will permit them?
Yes, yes, give him a copy.
But they're permitted to withdraw and file a withdraw.
Withdraw.
Fine.
Item 8.
No, here the petitioner grievance is that he made a representation to the opposite party for revival of the cooperative society, and the government is not taking any action for that purpose. May I pray that representation under Annex 2 be directed to be disposed of by the concerned authority, taking a decision thereon. And it is
There
in
is specific provision under the Cooperative Societies
yes,
Act.
yes, section 40.
40.
Section
So
40 of
what
the
it is
cooperative.
that an application has to be done before whom?
Before the opposite party number 1.
Show us.
Section 40 says promotion of cooperative movement.
No,
It
sir,
shall be
this is
the-
one thing. You
Madam.
wanted that, why not the dormant cooperative society be made alive?
Yes.
So under what provision and to who is the authority?
There it is. I am reading section 40 of the Odisha Cooperative Society
Sir,
Act.
40 is the main object
Yes.
for cooperative movements.
Yes.
But where suppose a cooperative society is dormant, I think the provisions must be there in the cooperative society. Is it already dissolved or what? You have to say.
It has already been liquidated.
Yes, sir.
And some are,
Then there is a provision under the act.
and some are in dormant condition.
Maybe, sir. So you'll have to approach the registrar. There must be a provision.
Yes, I have made the register as a party.
Representation he will not do, sir.
Maharaj?
What has happened actually? 40 is the object. Encouragement to promote the cooperative movement. So, it's wrong. But how can cooperative societies is dissolved or liquidated? Then he has to challenge the law.
It is only the state government who can look after the matter.
You want the provision that the state government is in power?
Because section 40, from section 40, the state government
No,
got
sir.
the power.
State government shall encourage and promote the cooperative movement. But
Yes.
suppose a step has been taken within the framework of this statute. What the state government will do?
No, but they have not taken any steps.
You
And
say
state
that it
government-
has already been liquidated, means dissolved.
Yes, some
The
of the
resolution
are
has come.
dissolved
Huh?
and some are dormant conditions, and they are not
What
taking
is the
steps.
dormant?
Means
Sir, if dormant means that they are not filing their returns, they are not auditing their account, then there is a provision you can approach our authority by initiating a proceeding.
no. Register of
The registrar order is there, when the liquidator is appointed, he has taken over.
Yes,
Then he has a right of an appeal against the order.
yes, appealable.
It's an appealable one.
Yes.
No, my lord, I am in a general context, not on only that liquidation part and the dormant position.
The difficulty is that the bold allegation or assertion will not do. Sir, if the registrar by initiating a proceeding passed an order under section 72 directing for liquidation, liquidator appointed under section 73, then the right of appeal against the order of the registrar is provided in the act itself.
No, I am not only on that part, and other parts also that which are also not functioning dormant and which has not been liquidated. That part also I am ready.
Have you given them any incidents?
Yes, I have given. I have given.
That which cooperative, according to you, the number of cooperatives?
Yes, I am in annexer 2, page kindly page 18.
Yes.
I have written all card bank have liquidated and cooperative officer.
So once the liquidation has come, it must be an order of the registrar. Yes,
No, that
liquidated. Section 72 comes into play.
Then again in the page 19, I have also mentioned the government established 65 numbers of RCMS in the state for benefit of farmers, out of which
they have also been liquidated because the registrar has taken over.
90% RCMS are in dormant condition due to negligence of cooperative officers and mismanagement and have been liquidated.
So it is already there.
No, many societies are there which has.
No, sir. This bold allegation will not do.
Mr. Bahali.
Yes, ma'am.
Each individual cooperative society have been liquidated as you have cited just now.
Yes.
That is emanating from some order under the statute. Under section 72 perhaps.
That I will clarify that some other provisions are there.
As stated by Mr. Debashish Tripathi,
yes,
that there is, you have a remedy.
No, I will clarify that other provisions of that Odisha Cooperative Society.
Yes, the liquidation order, there is a remedy provided under the statute.
No, not all liquidated, and some cooperative.
You have stated that, sir.
I will clarify. I will clarify, and I will show the provision of law. No, I will show the provision of law. It is only the state government who can look after the matter.
Mr. Bahali, you are annexer 2. You have drawn our attention to annexer 2. You have relied upon that document.
Yes.
So that document itself shows, sir.
No, entirely I have not gone shown it to the your lordship.
You have not shown with clarity that what has happened.
No, it is there. It is there. I will clarify.
Show us. I have not seen that.
Yes,
where it is there.
I will clarify. Let it come tomorrow.
No clarification is required.
No, because provisions are there. It is only the state government who can look after.
No, sir. Section 109 of the Act.
I will clarify the provision of law.
Sir, section 109 of the Act is very clear.
No, I will clarify tomorrow.
No, sir. We can't.
Because
that is clause, the key clause.
without the government interference, nothing can be done. And it is only the
No,
government.
no, it is a power of the registrar under section 72.
No, registrar only liquidate. He cannot revive the organization or he cannot operate the cooperative
Sir,
society.
that means where is the power of the state government that state government can do it? I have seen that power.
That
I have
section
seen
40
that
says-
power, but still,
Section
that is
40
that
says
is the
it
power of revision. Revision against an order.
No, section 40 says it is the overall, it is the government.
Oh, then we are saying, Lako.
You'll
Then it is 40.
No, tomorrow I will clarify with the
No,
authority
sir,
of law.
no clarification is required.
Tomorrow, let it come tomorrow. I will
No, we
provide
will
the
not. Disposal. Scott. No.
kindly pray for tomorrow, my lord.
No.
That I will clarify.
He has enclosed that letter itself, and which
I will show the provision of law.
The instant writ petition in the nature
May I
of the
pray, my
public.
lord? I will show the provision of law.
Yes. The nature of the public interest. Where is this guideline?
Look at under Annexure 4, you will see. Annexure 4.
Annexure 5. Which page?
Annexure 4 is at page 33, your lordship. Here, if your lordship comes to page 42. By
40?
42, running page 42 of that annexure.
Yes.
Annexure 4 is guidelines.
And this
Guidelines.
fee structure that is stipulated to be fixed and it was notified in the month of July. Now, madam, what has happened? Post facto the result and just 2 days before the counseling, they have enhanced. The comparative that I have given in Annexure 5 at page 46, your lordship says, which was 6.50 lakhs, was enhanced to 11 lakh 56,000. The first one. Likewise, the other one, second column, your lordship will see 5 lakhs 50 was enhanced to 8 lakh 50.
How far the writ court should interfere in this
And that is only this
fee structure? This is absolutely a policy decision. How far the court will interfere?
Only on the point of law in the sense that these fee structure regulation and capitation fee, everything was dealt with by the Honorable Access Court. It was directed that these fee is to be fixed much advance prior to the result and counseling. Now 31(7) they fix a fee structure and they issued a guideline. Now same guideline is superseded 2 days prior to the counseling. And that is where the problem lies, madam.
I'm just asking that whether what should be the interference by the court in this regard?
Only if your lordship notices a apparent arbitrariness, nothing beyond that, madam.
What is this arbitrariness?
Arbitrariness is when the fee has been enhanced almost twice the amount that was
So
stipulated.
what? Yes, who is for the state? File your response to it.
And medical counsel is there?
Your lordship
issued to OP number 3 because
Who is this OP number 3?
3 has issued this.
OJE.
Now, OP number 3 issued pursuant to the notification of the government. So, government is to also answer. Annexure 5 is by the government.
Issue notice. It will issue notice on the others, then the government, and you file your opposition. File the affidavit.
Grateful, man.
Canada.
Item 13.
Whether this pertains to in absence of the GST type.
Disposed of.
Item 14.
As per direction of this honorable court, I have filed the English translation copy.
Who against this?
Where is the translated copy?
Yes, I have filed also.
What is the agreement, brother? Has you read it? Government has given it.
The money from that, because of the technical experts' opinion that the facts are not true. So, are they taking back that money or they have already?
It's already the work has started, Malak. The work order is at page number 20.
Well, this is the temple,
Yes, Malak.
and if the government has spent money on the temple, why you are having so much of aversion to it? After all, it is for the betterment of the entire society.
Money is spent for that purpose, that temple,
That temple.
nothing else. It is not diverted to any other.
The project was given, the work order is at page number 21.
It is not a place. The government sanctioned the money. Patali Sikhetra Sonpur. Sonpur is a district headquarter. As per the archaeological survey report.
I understand, sir. It says that the historical event which everybody says is not correct.
No.
I understand. But there is a temple.
No, there is no temple.
There is no temple.
Temple are Malak, top of the hill of the Patal, top of the hill of Baghapali.
Then what temple they are refurbishing?
Distance between only 2 kilometers. One is Baghapali, another is Kotsam.
Sir, they are spending money for refurbishment or repair of a temple.
No repair of temple Malak.
They are saying that they have started.
Newly started a temple Malak.
What are you talking?
Page number 21 is the document manager talks about reconstruction development.
Wanted to reconstruct it. It must have been in a dilapidated condition.
But he is saying that there is no.
Specific instruction I have called for actually whether it's a new construction, it's a renovation.
Because at page 21,
New land.
At that, Malak, I have not received.
No. It is not reconstruction. It is a new one.
That
no,
That clarity, Malak, I don't have right now because I had already asked for that.
they are alleging, but the sanction is for reconstruction
Construction, sanction.
and the development.
That is a new one.
Sir, reconstruction means what? What is the meaning of means again?
Mal.
Construction means there was already a construction. It is being built again.
Malak. As per this money sanction in favor of Patali Sikhetra. But as per the archaeological report ballot, there is no such Patali Sikhetra, Baghapali and Kotsamle. But how the money sanctioned by the government and spent that this one of the disputed place, that is Kotsamle. That is a new place, manner.
What is the disputed place?
Disputed manner as per the local belief manner. Local people believe that at the time of Muslim invader, Lord
I understand, my brother has said.
The Kotsamle, the villagers Kotsamle and Baghapali, they are at dispute. But as for the local belief manner, this Patali Sikhetra, top of the hill of Baghapali. And there are still then Malad.
Yes, madam, you file your affidavit in this regard and tell us that if necessary, then you'll have to repair that temple as well.
This temple, as per the archaeological survey, which is near.
At the top of the hill?
There's nothing in the archaeological.
You just disclose the fact.
Yes.
Disclose the fact. Affidavit 1 week after. Matter to appear 2 weeks after.
Weeks or after.
1 week after the vacation, we are giving you so much of time. What more?
Page 18, last but one paragraph.
Yes, 15.
Adjourn to 13 January. Item 15.
Yes. What? Nothing. They will divert again. Don't worry. Yes, sir.
My lord, sir, kindly see the past on 13th of November. I had informed the Honorable Court that the date for eviction had been fixed. Challenging that, the encroachers filed a writ petition. That has been stayed. The eviction process has been stayed by the Honorable Single Judge. I had given the number also. Now, the interim order is still continuing. And the next date is fixed to 19th of December.
Next in line.
1 week after. On the prayer of the. Next.
Adjourned to 23rd December. Item 16.
No, 1 week after the vacation.
6th January.
19th is the date, so judgment would come later on.
6th January. Item 16.
How many? That's
13th January.
This is related to the bee apiculture farming in the Keonjhar district, which is highly affected area.
Oh, this is a bee culture.
Yes, here is now the state file one miscase IA for withdrawal of the counter affidavit. Lord, my humble submission, Lord, state who is the being a model litigant, so higher responsible before when he is filing the. That's Lord, I humble submit, Lord. So that's my humble submission. So again,
misinformation comes from my application. I am the bidder. I am L1. Since 3 years I'm spending my everything. Intervention may be allowed, that's why.
Regarding intervention, my learned friend, he can seek separate writ quits.
What is this? Then why multiplicity of the proceeding? Addition is only to avoid the multiplicity of the proceeding.
Already filed.
If it can be decided here, then why will drag him to another litigation?
But he has already filed a request, sir.
When once you have filed a writ petition, then
After filing this intervention, I filed the writ petition.
why you filed a writ petition?
I will withdraw.
Then you pursue. We will not allow this.
After filing this, I have filed.
Why? That's why that shows your malice.
No, not malice.
You wanted to make another everything in a confused state of.
Let me put the facts here.
Sorry, we can't.
A bid was issued.
Maybe you may have a right, but why after the addition? Why after addition you have filed? Then you pursue your remedy there. We are dismissing and recording that you have filed the writ petition, ventilating your. No, we will not tag it.
This purpose will be only solved because if I can execute the work, I am not standing.
Then this is what is a litigant's attitude.
Yes.
Is a litigant's attitude.
But I don't know to litigate.
So that is what you are litigant.
Because my point is very simple.
Your point is more complex.
They are saying that there is cancellation. There is no cancellation.
Whatever. Your point is more complex.
I am not alleging anything against him. I have nothing to allege against him because he is in my way. Just both of us are traveling congruently. We attached with it, Millers. That's the only prayer also. The petition may be attached to this petition also.
Will not. Why should I?
Because Millers, my problem may be seen for a moment.
No.
Just Millers.
You can't espouse the cause in this way.
2022.
Maybe you have raised the grievance in that petition. When it will come, we'll hear out. When it will come, we'll hear out.
Now they are saying that they have cancelled this tender.
Whatever.
It is not given to me.
You challenge. Say that.
I have already challenged that, Millers.
Then challenge. That will be decided.
My only prayer, Millers.
No.
Maybe I bow down to that. My only prayer that writ may be attached or else
why?
I will withdraw that writ, Millers.
A direction is passed in relation to another litigation. When that litigant is not a party to the proceeding. Is it a proper way of passing an order?
Then Millers, it may be kept pending. I will withdraw that petition. That will solve the purpose.
Withdraw first.
Yes. I will file a withdraw application today only in the course of the day.
File it.
Yes. I'll file this pen, maybe kept pending. It may be allowed, I will withdraw that.
Next.
My interim application will be allowed.
With cost. How much?
Are you ready with
Yes,
further affidavit?
Yes.
I filed already.
No, it's not filed. We'll file it.
Affirmed?
Yes,
Ready to be filed today.
it's ready to be filed.
No. Which one is yours, IA?
Flag C.
In fact, this difficulty was pointed out by me that this is a wrong statement. It was pointed out by me in my intervention. That is the
Flag C is there withdrawal.
Flag C means IA 21909 of 2020. not, no more.
Okay.
Yes.
Item 17.
May I please, my lord? This matter relates to Bangladeshi introduced, my lord. State was directed to file its counsel within 3 weeks.
No, what is the,
In fact, this matter relates to Bangladeshi intruders and illegal immigrants in Odisha, my lord.
so what you want?
My lord, state has to file its counter, my lord.
No, what, relating to what?
Kindly have a glance to the last protocol. Order dated 25/11/2025, my lord.
Does it not indirectly relates to an SIR? Because now the Supreme Court in one of the matter is in session and have issued a direction. All High Court should not continue or proceed with any matter concerning the SIR. We have recently, I think last week, the order has come. Will stay away because the Supreme Court is taking stock of the SIR matter.
Because, my lord, what I'm here? Because, my lord, Minister of Home Affairs direction was.
I understand. That is why the Supreme Court's direction is there, creating a brindle on us to proceed with those matters.
What the state is doing, whether they have any special
Have you
task
seen that order?
Oh.
Have you seen that order
Hey.
of Honorable Supreme?
Very recently, this there is a Registrar General. He was placing that order to us, and I have directed the circulation also
Circulation.
to all the honorable judges. Any matter concerning this,
If that be so, then I will go to that, my lord.
that is what. Then we can't proceed it. We will be acting against the order of the Supreme Court. We can't do that.
Submission, my lord. As per.
I understand. Whether
there is special task force.
That is what the SIR means. There will be a special task force that will be created by the central government, by the election commissioner, so that they will go and identify who is a citizen, whether their names have been given in the voter ID card, whether they are actually a citizen. Prior to 2002, anybody's name is already there. All these things, exercises to be done. And then to find out whether they are the illegal immigrants or they are the citizen of the country. This is the main objective. This is what you also want. But we appreciate, but when the matter is subjudice to the Supreme Court, then very difficult for us.
Not that the government will directed for all these actions, but
we have filed our affidavit. We have
Item 18.
our affidavit.
Let the affidavit filed by the state be taken on record. Copy has been given. Please. Copy here. 18.
My lords, I am on virtual. This is, my lords, the state of your lordship will kindly see the order dated 25/11/2025. And the state was required to take instruction. Paragraph 6 is the direction.
The draft resolution was placed before the committee members.
Yes,
to examine, to re-examine. What has happened? What progress?
Now, Millard, it is circulated to Department of Law and then GA Department.
What?
After that, Millard, it is transmitted to other department of the government, Law Department and GA Department.
Supreme Court has passed an order.
Paragraph 8 and 9.
Yes, they have decided to implement. They have said this judgment of the Supreme Court.
I am grateful. My lords, there is one submission here. If you are on a, and Your Lordship may kindly ask him to spare a copy for me.
Where is your
Associate,
counterpart?
I will get it picked up from him. My associate will be there in 10 minutes.
Pass an order on that basis, huh?
My lords, but there is one submission, my lords. I have one submission.
You have
Your
to
Lordship may
take active steps in this regard. You have principally agreed to implement. There is no difficulty. You have moved to other department. Let them give their final opinion on that. So we are keeping this 2 weeks after the review.
I'm grateful. My lords, I have one submission here. One submission.
Yes.
The Honorable Supreme Court, while deciding it in 2023, had referred to all hospitals. Now they have diluted it to only super specialty hospitals.
No, we'll let them come. They have, once they say that we want to implement the order as delivered by the Supreme Court, let them.
I am grateful. I am grateful. Let
Yes.
it be there in the board.
Yes.
I am grateful.
Yes. Next.
Adjourn to 13th January, item 19.
Sir, to get instruction on the engagement of CRCC.
What is the CRCCs?
Cluster Resource Coordination Company. This is in violation of section 25 and 27. So instruction is sought for.
You want regular teachers to be appointed?
Yes, madam.
Instead of CRCC?
Primary teachers.
Where is your affidavit?
CRCCs. That is not allowed.
There was a direct pass. Mr. Sasato Das was.
Your affidavit is filed on 27th November.
Right.
There, it is not recorded. Oh,
Flag B.
what is this? Flag B?
That is not. That was the earlier affidavit.
Earlier.
Yes, madam.
No, there was a direction passed on 25th of November. And then we feel that the government should disclose as fact in the form of an affidavit in course of this week. So subsequent to
It is the affidavit filed by affidavit.
that is on 25.
Pursuant to order dated
Oh.
11.
So that is the-
Flag B. They are received. It has been given on
This
28th.
was on 9. Again, one order was passed.
No, the line was only simply adjourned on his prayer.
The oral direction was made to produce the documents which engages these private teachers or CRCC.
Where are those?
Believe that.
Mr. Das has undertaken to take instruction. Now you will take instruction. On the other day, Ms. Patnaik will come, she will take instruction. Fourth day, Ms. Das will come and take instruction. What is this?
According to what? That's in courtroom. Are you not reporting what to do?
I think I flagged it. Next week.
Yes, I have filed another I also praying to call for a report from the Commissioner Secretary, School and Mass Education. File an affidavit stating, but how many private teachers are engaged as CRCCs?
So the court will be acting as the evidence collecting forum. He will collect all the evidence for you so that now you will make yourself more strengthened. Let us see, let them come. Next week, you just produce the documents.
Adjourn to 23rd December. Item 20.
For protection of the notified moment, the lawsuit directed to file an affidavit.
Whether I took time to file affidavit, it is admitted fact that they have demolished the boundary wall of this monument place. And accordingly, they are preparing and the superintendent.
Who has demolished?
This hooligans, they are what construction was done by the SI, that was forcefully demolished by the hooligans. They were from there.
As per the report, Annex 10, page 45, the circle inspector, age 45 minor, 15/5/2024. But the local police is not taken any action. So due to
Why these two men has been named and they have demolished?
local police pilot OP number 6, madam. Inspector in charge.
Who is these two persons? Vibhuti Charan Nando and Rajkumar Nando?
Yes.
Who are they?
Charan Nanda and Rajkumar Nanda.
Who are they?
They are the local residents.
So why they have demolished?
Forcibly they are demolished. Accordingly, we have intimated the collector.
Except
They are not
intimation,
taking
What
action.
collector? Why not the police?
Yes.
No, we have to intimate the police.
Right. For since 2024, local police.
But you may see the page 45 will be inspector.
Registered.
Thereafter, that letter they didn't have that file. We will file it. We have written to the
Yes,
the collector.
they state what the police is doing when this archaeological survey of India has written a letter. Will you not?
In earlier matter, affidavit was filed wherein precautionary measures were taken. That's what an affidavit was filed in earlier.
But what about these persons? The hooligans, they can't take the law in their own hand.
I will take further instruction. I have called for an instruction, but I have not received what steps have been taken by the police. They submitted the earlier occasion. This similar matter was placed, and in that affidavit was filed with all precautions.
Similar matter means this is a pending or a
Disposal.
Writ petition PIL 14.
It is the fifth writ petition. PIL. Series of
What is this?
petition.
Make them a party and we are issuing notice of
Yes,
them.
open
Let
number
them
6,
come.
ma'am. Open number 6.
These two persons.
Yes, ma'am. I will add them.
Add them a party.
Yes, ma'am.
Vibhuti Charan and
Yes, ma'am. Yes.
make them a party. We'll see. Leave is granted to the petitioner to add the officer to be here.
Mr. Pari, you are not deathless.
All except the section
Powerless
19 was
is there.
limited.
Item 21.
Yes, who is appearing?
The renovation work has been done in the old building which was existing now.
No, what is the dispute?
The old building is plot belongs to Nayanjar. Then
What is this? This is a government school.
yes, ma'am, government school, ma'am. And then government allowed me a land in 1982 in my name, the Urdu primary school. Yes, when the sanction by the government, my respectful prayer before a lordship is that amount should be spent in the own land, not to the land which belongs to the government.
I do not know. I do not understand. Sorry. My incompetence. I could not understand anything.
Where the amount spent by the government, the land belongs to Nayanjari, not belongs to the school. Then
What is
school
this Nayanjari land? What is this?
Government land, man.
Just beside the river bank. Just beside the river bank, which is used as a
Pathway.
pathway or some other purposes like grazing land or
Okay.
field.
Okay.
That line that is next to the river bank. So what he says that on that land school has come. So government has funded money to develop that.
But he says my land or something. I do not understand.
This has to be set up on their school land, not
No.
on a.
Where is the land allotted to the school?
My lord, page 16, my lord. Page 16, plot number 38. That land allotted to me, to the school.
I can't read. My brother will help me.
38, my plot number 38, page 16, my lord. Page 16, plot number 38.
Sir, you are well versed. I am not, sir.
No, 38 is written in English, man.
No, I do not know what is this. What is the classification of the land? I do not know.
Homestead land.
I do not know.
You mentioned in the annexure 2, my lord.
Yes.
Another friend can clarify whether.
I do not know.
By our books provide
My lord.
for supply of translated copy whenever there is one of these.
Sir, I can't read. That's my shortfall. What can I do?
Even if I read, sir, even if I read, I may perceive different way than my lord. If he doesn't read that, then what is the use of division bench? Reading a same document.
I'll the English person copy of document. But the thing is, only dispute arise in this petition.
I do not know where it is written. I do not know the last color. What is that color?
That's a homestead land.
Yes, Reman column.
That is in Bengali we call it a Montobbo.
Montobbo. Here also written Montobbo.
Montobbo.
Kharabadi 38.
And that land belongs to school and mass education.
Homestead.
And this land belongs to Shiksha Vibhag.
Okay.
Yes.
So Department of Education.
You're true.
So
Then
my
that belongs to Shiksha Vibhag.
And that land.
You don't want that.
But this school was established much earlier.
1971.
So if it is running from that particular land, how you wanted the
That's my submission. That now that 1971 school running, that now no school is there. Now
school is there means
1982.
She said that there were 2 asbestos shed room which was not in a very good shape.
No,
so they have taken to cast the
school is not running at that plot.
What are you talking?
Because
They are
school
saying that
running
it is under jurisdiction.
plot, but the government allotted school and mass education to the present school.
You can't. That's I do not know what is this. But this school is, according to you, is run there.
No. School is run in the plot number 38.
It is already renovated. What is the said room is now being renovated by the PR department with concrete roof.
That's the copy I have gone to the
concrete roof casting by replacing the
asbestos sheet.
I just gone through the instruction taken by the State Council.
Sorry.
Has been constructed.
Reconstructed, renovated at the same old plot only.
That's true. I understand.
But that plot is not belongs to the present school. That is my suggestion.
Sir, it may not, but the school is permitted to run on the said plot The school is run by the government, with the aid of the government, with the money of the government. It is a government school. You said it's a government school. If it is a government school, let the government take care of it. They want to spend at their school, then we can't. You wanted this shifting of this school to a land which is standing in the name of Shiksha Vibhag.
No, my lord.
This is what is there.
No, my lord. That plot not belong to the school. That is my submission.
Sir, it belongs to the government.
Yes.
So, as the government is running the school, why it will?
Education department, not only government, it is education department.
I have allotted land for the same school without constructing the lot allotted to the school. They are constructed in a different
Who has allotted, sir?
My lord?
Who has allotted?
School and mass education, my lord?
Sir, however, which you have control, that speaks that school and mass education, the school, the education department is the recorded. Then the plot number. The plot number is recorded as homestead. Then what is your difficulty? Now that whatever asbestos roof was there, they have removed the asbestos roof so that the children will not be affected if any untoward situation happens. That's why they have renovated, they have made it concrete.
I have gone through the inspection taken by the State Council. But they have construction plot number 27. Not 38.
That school which was constructed in 1971 was a plot number 27, which
Yes.
is the irrigation department
Yes.
plot. At the same area, now that school is continuing and renovation work is done in plot number 27. The allegation, the petition.
He
contains
wanted,
that-
now that is what he was saying was going above, miles above my head. So I was unable to figure out that what he really wanted to say. Now I got the clarity in this, that this school is run at plot number 27, which is recorded in the name of the irrigation department. But the government has set up the school. Irrigation department has never raised any objection. It is being run very smoothly from that plot. His contention is that why in plot number 27, which is under the irrigation department, it should be a plot number 38, which is under the Shiksha Vibhag. This is what is, so shifting of the school from that plot, nothing. If the school is seamlessly run, the money is funded, money is given, what is the difficulty? And what is the distance between this plot 27 and 38? I think it will be very close.
Yes, ma'am.
Very close. Intervening plots would be hardly 9. And may not be of big size.
Another thing, my lord, it is 18 also policy. The structure of the government, unless and until they take permission from the Tahsildar, and they are not renovated or constructed, they are also not taken permission from the Tahsildar.
Sir, they have already renovated it. They will take care of this, nothing more.
They will not.
We are concerned with the running of the school. Let the school run. Let the school run. You can't dictate where to. And shifting of the school, do you know how it will affect the seamless study of the children?
I don't want.
You don't want.
Why?
Sorry, I can't. Let the children be benefited by that.
School plot. On the.
Sorry, we cannot. It's a government school. It's not your school. Is it outside the government? What are you talking about? This can't be done. You can't have a PIL in this fashion. Sorry.
Page 18 also can see for a movement.
Come. Yes.
Page 18, madam. There is collector circular. The government fund cannot be utilized without the permission of the Tahsildar. That is also there, madam. It's a government circular, madam. Page 18, madam.
So the finance department is absolutely farcical. No step. Finance secretary is powerless. He's a teethless tiger. It is a Tahsildar who is more powerful. He will see where the government money will be spent.
It is specifically, madam. No,
this is what is there.
No construction work by any nation.
What authority he has?
Initiated.
It is the government who will allot the fund.
Launched without any permission of Tahsildar. This is a circular of the government.
It's not a government circular. This is a collector's circular. Not a government circular in that.
Circular, this is issued by rule issued by the government minor.
No, maybe.
Specifically mentioned,
Cannot be done.
no construction work of any nature shall be initiated on government land without prior permission of the Tahsildar concerned in writing.
So it has been taken.
Said you have not, perhaps miscommunication from this side. Collector's decision is not a government's decision. That is what.
It will come from a finance department. They are the authority who will sanction the money.
And except 5 is pending, they can dispose of it. Except 5 is pending, madam.
Again, you have chosen a wrong person. For consideration of representation, I have the last reservation. No. Not keeping any dead wood alive all the time. Unnecessarily, no,
My grievance
sorry.
is absolutely correct.
Sorry. No, we'll say that, yes. The instant writ petition in the nature of a public interest
52 once if it can be taken up today, madam. Because madam, the contempt matter is this.
Yes, we'll take up, don't worry. Yes.
Item 22 regarding the PD procurement matter.
What is this matter?
PD procurement.
What English you have written? Procurement.
Procurement.
Is a procurement. First page. Preamble.
Direct from state to up in instruction.
I received some instruction, but it's not appropriate. Received some instruction, but it's not complete. It does not give the complete picture. If I may be granted some more time.
Now this is the innovative way.
But I have received some.
Saying that no instructions now is a very reformatic way of saying that some instruction, but not complete instruction.
One opposite party number 5 has given instruction only with respect to RTI statements, but other main grievance which is raised by the petitioner, that instruction does not receive.
So now it has got a self-life. What they will do with the paddy if you do not purchase? I think MSP you have already fixed. So why not? What is the policy which has been taken? How much you want to purchase? You can't purchase the whole of it, I understand, but
Conduct of the opposite party number 5, 8 lordships, they not properly identify the suspect's plots and reject the plots which information provided by the petitioner's lordships.
what is this cooperative society?
This has to go, madam, because there are some allegations made against party number.
Notice. Second week.
In January. Item 4 item 4 will be taken.
Which one? Will it, in this matter, I have received instruction that the land is de-reserved and the construction of the building is continuing.
Then in that event, nothing. Brother, on that one. It has already been reserved and continued. Disposing.
Item 4 before
Actually.
Item 23. Item 20.
May I please your losses, my lords? My lords, I am permitted to appear to BC, my lords. The last occasion, a lordship specific query was that instruction was given to, direction was given to state government, so also to me, to find out the plot number 81 belongs to whom.
What is this?
It's here the PIL is, here instructions are received that it is governance land matters, but the construction is not able to be constructed because of the dispute between two villages.
So there is another writ petition which is pending.
That was disposed of, my lords.
So basically, of matters one. First, petitioners approach, thereafter the opposite parties approach. There's a dispute regarding two villages regarding construction of.
Then who will resolve? What for you are there?
Yes, my lords.
So you have to take a conscious decision what to do. It's your policy decision. You can't keep the things in abeyance for such purposes.
Word order already issued back in 2018, my lord.
Whatever, then you'll have to implement.
That
Why you will not implement the order?
fresh steps, I've already told the department to take what.
No, then we'll have to pass an order that whatever you have done it, merely because somebody is dissenting, you can't stand in the way. You can't just keep everything in halt. You have to take a decision, madam.
The only problem which the department is, the officers are having because of the law and order situation at that particular phase.
Sir, this is your subject, sir. I think in the 9th schedule or a 7th schedule.
Even police
7th schedule, that's a state subject. Public law and order. So, will you not?
Even police protection was called for.
So,
But somehow, this.
why the police has not given a protection?
That was also given, my lords.
So, why you could not do it?
There's some lacuna in between why did not it.
No, no, madam, it is not.
And also, my lord, it may be considered if an alternate plot can be considered, my lord.
I do not know when what alternate plot means. This is your plot.
Because of the dispute between two villages, if an alternate plot can be considered.
Why? This is, you have to take a conscious decision what to do.
One village does not want to be constructed at that place and the other village.
Madam, then what? Then you'll have to take a call.
That is the.
You have to take a call.
I can be.
And the people of both the localities cannot be deprived, because that's the policy decision of the government to set up the Anganwadi centers.
And also as
Because the services have to be ensured at the doorstep. Why you will not do it?
This could be an alternate plot could be suggested to avoid.
That is up to you. That is up to you. We are giving you an opportunity to file affidavit. You flag it, then we will decide it. Affidavit. By 1 week after the. I'm just sitting idle.
So the alternate plot is also.
It is up to you whether to find out or not to find out.
20th January.
There is a matter where the petitioners are all belong to cadre of assistant commander. Odisha
Belongs to?
assistant commander. Hello, Odisha police has two different and distinct cadre. That is Odisha Police Service and Odisha Armed Police Service. The page 29. Annex 3, that is the rule 309 rule framed in 2013. That is Odisha.
The notice has to go to the Advocate General, because you are challenging the vires of Section 4 of the Odisha Armed Police Services. What is that section for?
That is the page 31. That not more than 25% of the posts in Group A, senior branch of the service, shall be filled up by officers of Odisha Police Service Group A, senior branch, who are recruited to the Odisha Police Service Group A, junior branch under the Odisha Police Service Method and Recruitment and Condition of Service Rules 2010, directly through combined competitive examination conducted by the Commission in accordance with the Odisha Civil Service. So, my lord, in our cadre, Odisha Armed Police Service cadre, 25% will be taken by the Odisha Police Service. Those are a different constitution of service and different, our also different constitution of service.
So,
my lord, in our, we are 100% in our small cadre. 75% for promotional post only for Odisha Armed Police, and from our cadre, 25% promotional post will be for them.
So it is unconstitutional. It is unconstitutional.
My point is, my lord, because
Notice to the Advocate General.
my lord, now
2 weeks after.
finalized, my lord, the gradation list.
What can be done?
So, cadre,
We'll see to it. We'll see to it.
Last occasion, my lords have permitted me to make the deposit as a bona fide gesture. That is what I have deposited, my lords. I am giving copy of challenge to lords, my lords. That 128A, it's some lords provision to give effect to litigation policy by if I make payment of the whole tax on a 128, the interest and penalties to every lords. And appeal is withdrawn, my lords have seen the other day. And payment is made, whole payment.
To consider.
Exactly, my lords.
Your application.
Yes, that payment is
The
made, my lords.
application has to divide.
Yes, and they have to just issue SPL 05. That is the requirement of law. To put an end to 128 minutes, once the entire payment is made, because only they are objecting because one of the component of payment out of 36 lakhs, about 1 lakh 30.
1 lakh, I have understood.
Yes,
The
your
major
hospital
portion
will-
has already been done.
Yes.
One smaller portion, you have done it from a credit ledger. It
Exactly.
should be from a cash ledger.
Yeah.
We understood.
And my friend has also been very fairly.
So now you have deposited it. Now you have deposited it. Now
and that money
is more than a cash ledger.
And
because the money has directly gone.
Your Lordship may kindly narrate at the time of passing order that the peculiarity of the case is this.
It will not be treated as a precedent.
Correct.
Not a precedent and not consistent because entire amount has been
Yeah.
entire amount has been deposited prior
Oh, that is what we are saying.
and application.
We are passing order. Judgment of us.
Order also has a binding effect.
Your Lordship, only peculiarity.
There is a peculiarity.
Prior-
In a small amount, a fraction of it, a negligible amount appears to have been.
Prior to the due
It's not that his intention was not to.
Copy of that.
I have given this.
It is not that his intention was to avoid the payment. As a special case.
And SPL 052 issued and 1 lakh 36 to refund the bill. Now that is paid, that is double payment. My friend also accident. Yes, yes.
That
given application that will be
Only small
reversed.
observation brought him. He has accident. My friend is fair enough to accident.
Yes,
He
call
said,
the next.
My lord. Diplomat.
Second 21.
So why I am
that is-
submitting your Lordship because there is a cut
Oh,
of
I understand.
date for that.
I know that.
Pardon, His Lordship, this matter the learned Advocate General will argue, Your Lordship.
This is the condonation has been done.
Lordship,
Single the honorable only said that in the event if judgments are applicable, then the court will and for this person.
No, condonation has been
To do this.
allowed.
No, pilot deal also can pay 42. Because there are a lot of many similar matters are there confirmed by the Honorable Supreme Court. And that is the reason why Lordship in order to keep sorry, madam. No, that is true.
Yes, Your Lordship's last order.
Yes, or 1 lakh has been deposited.
No, my lord, 1 lakh has been directed to be deposited within 4 weeks from the date.
Correct.
So 4 weeks completes on January, 2nd of January. So what I pray, my lord, let.
Oh, still you are waiting till the last day.
No, not
Okay.
till the last day, but send this order to the authority. They will comply with the, unless they comply.
No, that will cost more than 1 lakh.
Maybe they are taking the risk. We do.
Have you applied for certified copy
Certificate, my lord, I have sent my
of
lord
this order?
directly to them.
No. Have you applied for certified copy of this order?
No, my lord.
Why?
Hopefully they will not go to because
No, they should.
Not to the petitioner, but to the other. Had it been to the petitioner,
My
probably they would have
instructions
gone.
are, they have sent it to the finance for the approval of that money. To that
Over this order of our court.
finance approval.
Finance department will approve.
Yes, that's the amount once.
The Honorable Court has allowed the condone the delay. That has been set aside by the Supreme Court, saying that no, they
From Andhra.
Andhra. The Sunod of High Court, Sunod of because I cannot read the state government separately.
That is why the Justice Party wala.
No.
What to do? What is the matter, Vinay? The point is what? What is the just one line?
Point is very limited.
One line.
Point is very limited. Well, petitioner was initially appointed as a NMR and a DLR.
I do not know this term.
Non-master role. That was not through any selection process, but an appointment.
Daily
was
base
given.
rated. You can
Yes.
Daily rated worker.
Daily rated work.
Say so.
Subsequently, his service was brought over to the work charge establishment.
Work charge establishment.
Work
Yes.
charge establishment in 2011. Then he retired from the service in 2024. Before his retirement, his services were never regularized. Now he approached this honorable court with twofold prayer. One, for regularization of service from the date of initial appointment. Second, for pensionary benefits, as he has already retired from service. Now the honorable court, referring to the judgment of one Pradeep Kumar Panigrai, disposed of the writ petition. Of course, disposed of the writ petition.
There are two judgments on a work charge employee.
Yes.
A Supreme Court judgment and there is a Calcutta High Court judgment.
Recently, batch cases also disputed on
Calcutta High Court judgment.
Recently, batch of case of the state government.
Unfortunately and fortunately.
But here the dispute is
authored by
here the dispute.
What is the the characteristics of a work charge employee?
Now, my lord, here there was no specific direction for regularization. All that the honorable court, after observing that the case of the petitioner stands in a similar footing with so and so case of Pradeep Kumar Panigrai, directed for consideration. So consideration, if your lordship, if we will consider, our hands are tied because of the observation made by the honorable court in the preceding paragraph, holding the case of the petitioner already equivalent to the case of Pradeep Kumar Panigrai. Pradeep Kumar Panigrai, they went.
Have you accepted or not accepted that Pradeep Kumar Panigrai judgment has been accepted?
Pradeep Kumar Panigrai judgment confirmed it. I don't dispute that. It was confirmed in Supreme Court, but the question of law was left open-minded. So, lordship.
SLP dismissed.
SLP dismissed.
Then there was no confirmation.
SLP simpliciter, but question of law was left open.
So there is no.
So now, my lord, in absence of any specific direction for regularization, now the period of service rendered by the petitioner in work charge establishment, he can only be entitled for pensionary benefit if at all, as per the provisions of the pension rule, his service, after rendering a particular service in a work charge establishment, if before his retirement, his service is regularized, then the entire work charge period of service will be taken into consideration for the pensionary benefit. That is the provision under the Rule 18 of the pension rules. But here is a case where the petitioner, after being brought over to the work charge establishment, simply retired in 2024 and his service was never.
During the currency of his employment as a work charge of employee.
Yes.
Did he approach the court with the writ petition for regularization?
No,
or it is after superannuation?
He approached the honorable court in 2024.
When he attained superannuation?
Before his superannuation, I think there is no writ petition. As the record reveals, there was no writ petition prior to his superannuation.
So let him come when he will argue. Give me a date, but a firm date.
A firm date, my lord. I pray, my lord, on 4th of December.
4th of December, 2026.
4th of January,
So,
2026. 4th of January.
4th is a Sunday. Will he come? Let us sit. If you agree. That is the December.
Cases which have been referred to, well, these cases also after the retirement. That has been confirmed with you. So notice that my lordship is not correct that his lordship has said that it is similar. The absolute his lordship has not observed that. It need to be analyzed by the government. If in the event it is similar, then only give benefits. That is the direction.
But we'll clarify this.
Your lordship may kindly see the.
No. If he says so, then we'll clarify the order to that extent.
The order is clear.
That in the event he is at par with that,
yes,
then the similar treatment.
Yes. Well,
if he is not at par with them, then not similar treatment.
Because once notice is issued means counter.
This other case is concerned.
But so far as the provision of rules are concerned, those are.
But you have lost up to the Supreme Court, sir.
Not only batch of
That
cases.
was only.
Hundreds of cases.
Sir, you have lost up to the Supreme Court. So may not be a merger, but it is really a binding judgment of a division bench.
I think many.
Recently, around 100 cases, my lord, they lost in Supreme Court. Around similar matter, 100 cases, around
100 cases, they went to the Supreme Court.
Yes.
100 cases.
In 2010 or 12, Mr. 2010 or 12, this court has, in 2010 or 12,
Yes.
this court has said that notional.
No,
Yes,
right.
Exactly.
Exactly. That is the direction. That is the direction. For the particular case, that is the direction.
I think Justice Judge.
Yes, madam.
I have referred to in my.
Yes, madam. That lordship is correct.
Judgments
Yes, madam.
sitting single.
That is correct. Lordship is absolutely correct.
I just
Yes, madam.
reminded of 2012.
So where is the difficulty on your part, Mr. Das? Because if he says that the court has not said that you treat him as at par with them, only court has said that if the case is at par with that case, then you will definitely extend all the benefits. So you'll have to take a decision. If you say not at par, fair enough. If you say at par, then how can you defy?
The court has said that it is similar.
But he is saying that is not. We clarify this position. That this portion where it is perceived that it is similar is hereby modified to the extent that in the event the petitioner is found to stand on a same footing, then he cannot be denied the same treatment.
Lordship, may kindly see para 8. Sir,
This court has said, this court in many similar cases had taken on identical scope, as has been taken in division bench, the Pradeep Kumar. Thereafter, the direction part is paragraph 9. Taking into consideration so within 2 months you have to do it, and further the opposite party number 1 shall do well to consider the representation of the petitioners in terms of the analysis made here in above, as well as in terms of the order passed by division bench in so and so, and the representation of the petitioner shall be disposed of by passing a speaking and reasoned order within the aforesaid time stipulation. In the event it is found by the opposite party number 1 that
similar to that
petitioner's case is similar to that of so and so, and in absence of any legal impediment, both conditions.
Both conditions. If your lordship may kindly see just one line from para 8. One line.
Clarifying also, it is very clear.
One line from para 8.
Purview of writ appeal, you know.
The Honorable Court has observed, in the aforesaid context, this court examined the order passed by the division bench of this court in Pradeep Kumar Panigrai. On careful consideration of the said order passed by the division bench of this court found that the factual background of the aforesaid case is almost identical to the facts of the case of the petitioner. So this observation.
But what is the ultimate paragraph?
That is by ultimate, saying that you examine, and if it is found, then only, otherwise no.
With that clarification, this can be.
Clarification is already there. Only some observation you want.
This
writ appeal, you know.
Observation in para 8 will not stand in the way of.
What are you talking about? Para 8 is something.
Para 8 to lordship.
Nothing.
My lord's order, that order for deposit of that 1 lakh, that is also not applied.
Also, we have to keep it pending for final disposal on 5th.
5th of January.
Or 6th. 6th is the day, na? As a first matter, you just keep it. We'll dictate the order on 6th.
But
Then the 6th then.
No, it should be the first matter. As a specific matter on 6th.
For others.
Yes.
These 4 appeals are identical.
Huh?
These 4 appeals are identical in nature.
That is why with. That is why with.
I feel the moot question that will pause for consideration if before your lordship would be binding effect of a coordinated judgment. Now it is by the honorable division bench. Recently, your lordship has appealed the earlier judgment. Niharanjan Vishwa.
No. Binding effect of
Coordinate bench judgment. In fact, this is regarding allotment of houses by LIC of India.
oh, there was one.
Recently appealed the judgment by the Supreme Court. But that judgment was cited.
No, there was another matter before us.
That's right. That is the judgment I'm saying. Kindly see. Page 158 of this compilation.
What?
But your lordship has upheld the judgment wherein they challenge the auction process of allotment of water.
Was it cited before the single bench?
Yes, it was cited. Not your lordship division bench, but the coordinate bench judgment was cited because by that date, the division bench judgment had not come. So coordinate bench judgment was cited. Just your lordship may turn to one page. That is page 111. But the honorable single judge has distinguished it saying that cause of action and prayers are not similar. 111, running page 111.
Yes.
Cause of action and prayer are not similar. The decision to go for auction was not subject matter of consideration.
Yes. Consider the Queen versus Lytham. That's a very celebrated judgment.
But
so can't find fault into that.
No, I am not finding fault in that. I am finding fault in the finding portion wherein the honorable single judge has tried to distinguish it. That's not correct. Kindly see page 111 and page 98.
Yes.
Kindly see bottom three lines. Even the cause of action and prayers are not similar. The decision to go for auction was not subject to consideration, which is factually incorrect. Let you see the single bench judgment of this very same law. That is at page.
Notices has to go.
Number 3. May I be pardoned, my lords, I am on virtual mode. I am appearing in item number 3 personally.
Kindly see my compilation, that is page 151. Para 2. What was the challenge there and what is the challenge?
1682. 168.
That compilation.
You are for LIC.
I am for LIC. But in fact, triple C, that's the proposition. I'm saying that the honorable single judge has probably has not considered this aspect that if a lordship sees para the beginning part of the judgment, I'm impugning before my lords below, page 98, kindly see.
Yes.
The essential grievance of all the petitioners is against the decision of LIC of India in refusing to follow the lottery procedure and was assured to done. LIC claims to have changed the policy to the effect that allotments are in public option. So that is the challenge before as the honorable single is writing, but there are other players also in this pitch. Now, if this is the position and the coordinate bench judgment which I am citing, kindly see page 151 of the compilation as given and upheld by my lordship. Para 2.
One.
Para 2 of my compilation. The compilation of judgment given to
What we have held.
Your lordship has upheld the earlier judgment, the coordinate bench judgment which was cited before the other bench, upheld it, saying that in absence of challenge to the cancellation, you cannot challenge the auction proceeding. And delay and latency, your lordship has taken a ground here also, but delay and latency is not the point here, but auction is the procedure. Now let's take your lordship the facts also. Kindly see page 151 of my compilation, para 2. This is the judgment upheld by my lord.
Yes.
Kindly see para 2, the petitioner in the so and so challenges cancellation letter and e-auction notice dated 9/3/25. He also seeks passing of these notices and a direction to LIC to register and hand over possession of previously allotted flat upon payment of remaining consideration. And this judgment was challenged in that case which I am showing to my lordship. That Niharanjan before, your lordship has upheld this judgment saying that delay and laches and other parts essentially upholding the auction procedure. Now, when this single judgment was cited before the coordinate bench, when this impugned judgment was being argued, that the honorable single judge are distinguished in the manner your lordship will see. That is what I am trying to point out page 108. This is one part. This is one. Now coming to the facts.
No, what? Why he has distinguished?
Kindly see no. I fail to understand how could the honorable single judge say the cause of action and prayers are not similar.
No, that is one line. Don't say. Main thing is the other aspect. One line does not mean that the entire judgment is absolutely based upon it. So don't challenge the judgment on this one line, which was unwarranted actually. It appears to me this is really an arbiter. It has got nothing.
Now let me come back to the position of this issue.
Yes.
But total flats, if your lordship will see, out of 228, 153 were allotted by lottery process. Prior to 2014 in the Registration Act coming into force, means in the Registration Act by virtue of an amendment in 2014, an amendment was introduced that without an ROR, there shall be no registration of any property in the Odisha amendment. Now, prior to 2014, out of 228, 153 flats were allotted, registered, and they passed on. Now, after 2014, I'll show to that amendment below. In view of the prohibition contained in the Registration Act, LIC could not register nor could part away deliver this property to the allotment. Now, that in fact remained there. Thereafter, all this period lapsed, and LIC thereafter decided that these applicants who have only paid application fees, not towards consideration, application fees of 1 lakh, they will now resort to the auction procedure instead of lottery because it's a public sector undertaking. The amount that is invested by LIC that will undergo, in fact.
Initially, the lottery was conducted and some of them were already chosen, and the letters of allotment were also issued to them.
Yes.
So now they have a profound hope of getting that.
Yes.
If I correctly remember in that judgment, the plea was that the government raises an objection that this land over which you wanted to make a construction, I think that land, correct, that is a forest land. And that was a reason that it was stalled for a pretty long time.
Forest?
Ultimately, it was removed. There was a writ petition at your behest.
Right.
Means the petitioner also filed a writ petition.
Yes.
And ultimately, this government decided to free it, that it is no longer a forest land.
That forest part was clear.
And thereafter, now these persons who have been given an allotment letter.
Yes. Not all, out of 75.
Whatever, right. I'm saying the persons who had been given an allotment letter, they came forward and say that why don't you register? I want to pay off. But this was a case where he was keeping mum, he was sitting tight, he did not approach the court promptly. There were other cases where they approached the court promptly.
These are those
cases. And the court passes an order directing you to execute the lease deed. Is it?
Yes.
So I said that you were sleeping in a slumber.
Not me.
I mean, you means the petitioner therein or appellant therein. You were sleeping in a slumber. So at this faggot, you cannot come forward and say your case stands on a different footing than the other's case. And the parity was not drawn.
In In fact, they are not sleeping in slumber. They had approached.
So on that very first line shows that morning shows the day. So that first line shows the ultimate decision
But in fact,
of my judgment.
in fact, these petitioners, they had approached in 2014. So they were not
So that's why we said that they may have a right to claim.
Yes.
There is no difficulty, but you cannot because you came much later.
In your lordship judgment.
Yes.
Right. That's it.
That's why a delay in laches.
Yes, that's why delay.
Because I dictated in the open court, so I remember the facts.
Delay in laches, your lordship has also dictated in the other part, saying that without challenging the cancellation, you cannot challenge the subsequent consequence and action of auction. That also was in the finding of the lordship, even by your lordship. That is your lordship judgment. That was the case. Auction process was challenged.
But here, once the lottery was conducted, once it has been done, you cancelled it. The cancellation is challenged.
Cancellation.
So then your cancellation was founded upon that the government had raised an objection that it is on a forest land.
Yes.
And now you succeeded in your writ petition, the government has. Then the cancellation cannot stand. If the cancellation goes.
We have not succeeded. Government from
whatever, succeeded means ultimately you could get the land cleared from the forest. So now are you not bound by your own
There is other part. There is other part. The other part is the amendment in 2014, in fact, stopped LIC from making any transaction.
What transaction?
Registration of sale.
Why not? ROR. Now you have done a ROR. Have you done the entry in the ROR?
Yes, sir. Now by the time
do it.
Now
do it.
Now things have changed. Now the LIC has taken a policy decision not to go for lottery system. It will put to auction. It has in fact put to auction. Out of 75, 70 flats are all put to auction. It has gone to the public. It has made very high amount for LIC. And the people have paid it and they have taken the flats. Now these flats, it will amount to a discrimination. Those persons, they will now say that is the position.
What will happen in the civil law? A person has entered into an agreement for sale, say in 2000, and then pursuing his remedy by way of a suit of a specific performance of an agreement. And then a person who purchased the same flat in 2015 at a higher price, suit for a specific performance decreed. Would you say discrimination?
Decreed only
because the price is 4 times
not the question of
that the agreed price at one point of time.
Let me tell you, Lordship, what the problem.
You can't resile.
Let me tell you, Lordship,
If you agreed to sell, if you cannot sell, they were not at fault. Had you sold those property in 2014, you could not have said that you are losing.
We could not have sold.
The problem was created at
by the government.
At your behest.
No, not our behest. That's the issue. That is the issue, my lord. Not we were registering it. We were giving out the process.
So according to you, if some impediments is created by the government,
yes,
it will be used as a bonanza.
No, it's not a bonanza.
Then
it's not a bonanza. It's a question of change of circumstances. It's a question of change of valuation of the property.
They came promptly before the court. They wanted.
Sit up.
See, why you could not register?
Sir, can it go? Sir, just imagine a person. It's a question of willing buyer and a willing seller. You know the concept of a willing buyer and a willing seller. You were the willing seller, they were the willing buyer. They applied, they wanted to pay you money. The willing seller says, I can't take your money. There is something which has happened to me. I can't take your money. And then he remained at your diktat.
No, we immediately cancelled
Please.
it. Immediately we cancelled
Now then say you can't cancel it.
No.
A right once it accrued, then in that event, had it been a case that you abandoned the entire project and say, I can't go, is all gone, I'm not going, I'm abandoning it, I'm not going to make any constructions. That is the one aspect.
Right.
But the moment you say that no, for beneficial interests or a commercial viability,
Commercial viability,
yes,
sir. We are a
always
undertaking. We are
you say, sir,
we are not.
OPL Act, it has to go to sub-collector. Remitted the record to sub-collector. Sub-collector, keeping it for 4 years, after he remanded the matter to the Tahsildar for fresh inquiry. That was order was challenged by the prisoners before the ATM, the collector, the revision authority. Revision authority, after hearing that, the Tahsildar's order is very clear because after thorough investigation it has been done. So it set aside the order of the sub-collector. And but that order was passed in 1988. It remained for many years. The order was not acted upon. In 1997, we filed a writ application to implement that ATM's order. So during pendency of the interim order writ application, the sub-collector preferred revision before the RDC on the section 12. Again, second revision before the assembly challenging the ATM's order. Challenging the ATM's order. And the RDC allowed the revision of challenging which we filed a writ application. And the Honorable Single Judge, the basic ground was that first of all, it is beyond 15 years, so between beyond period of limitation, because the statute as per Article 137 of the Limitation Act, if there is no period of appeal is provided in the statute, then it will be 3 years. So that is a division by judgment of this Honorable Court also to that effect. And also we are also relied on the Supreme Court judgment where it says that even 1 year delay is also treated as a unreasonable delay. And that another division is decision of the Honorable Court. This is a 5 years, that was division was filed 5 years after that was also held to be unreasonable, and division of order was also set aside. Then another order, the second division was not maintainable because the ATM which has exercised the revision power challenging that division order, second revision for the RDC is not maintainable. That part, so Honorable Single Judge relating to village police, actually the land originally belonged to village police officer. So relating to the Village Police Abolition Act, which is not the subject matter of the petition, his lordship has decided the case. Let's kindly see the lordship kindly see that. Which is not the subject matter of the case is the Public Provisions Prohibition Act. Prevention of Land Encroachment Act. Sorry, Prevention of Land Encroachment Act. My lord, may kindly see the entry by order of my lord. So the revision limitation, I cited all the judgment for the Honorable Court. Written order submissions also there. Honorable Single Judge has not considered any of these conditions or contentions, and it has not reported any of these judgments. So that record is there also for lordship. My lord, can see. The village police abolition is not possible to settlement. That is not subject matter. It doesn't say that there will not be settlement. Question. Because after the abolition of the Village Police Abolition Act, after the Village Police, after the vested, it became the state government. That is the reason state government initiated the encroachment proceeding. Let's not tell you, see the page 35 of this book. And also another condition that all the parties are not notice, or revisional court has not noticed all the parties, and that is also another contention.
OPLE Act. Yes.
So, so that division up to 15 years was not maintainable. It was clearly barred by limitation. And also
Tell me whether there was any proceeding initiated under section 4, 5, 4, 6, 7 or 8 of the OPLE Act.
Yes, my lord. In that proceeding only this order was passed by the Tahsildar recommending for settlement before the sub-collector. In that proceeding only. In that proceeding only. Can you see the petition record by lord? In that proceeding only. Otherwise, there is no scope for the Tahsildar to pass order. It has
What is the nature of this land which was
now it is
under that particular act? No. This was a land which is described as Chaukidari Jagir land.
Chaukidari Jagir land. I mean the Chaukidari Jagir land, but that land was homestead land.
That land was
homestead land.
No. What is this Chaukidari Jagir land is
village police that previously village police officers.
Does it have a special character?
No, the village police officers, they used to get the lands for their services.
From whom?
Sorry,
from whom?
From the
ruler. From the ruler.
From the ruler.
And then after this, the act came.
Yes.
The land vested.
Vested in the state government.
Vested
in the state government. And vested in the state government.
72.
1950 abolition act.
Written in the government.
Under what law?
In 1964.
What is the law?
My law is that
No. Which law?
Village Police Abolition Act. That is under the Village Police Abolition Act, my lord, 1964. That came in the abolition. Police officers of Village Police Abolition Act, 1964. That is the law.
That is the law.
That is the law.
So, what was the nature of the land which was described there?
Nature of the land, my lord, relation can the Jagged lands in relation to office of the village police means land which by whatever means described or locally known whether or not recorded as such in the settlement papers held as emolument in respect of such office. That is the definition chapter section 2E.
Now that is the position. Suppose if the land has a special character under that act, if the act is repealed, then what would be the nature? What would be the nature of such land?
Not repealed. Act is not repealed. Act is there. Act is there. Act because by virtue of this act, the land got vested in the government.
What it says that when all this land shall waste into the government.
Yes, my lord.
Which is the provision? Can you give me one spare copy?
Yes, my lord.
Or two spare copy to both of us?
I'm sorry, my lord. By mistake, yes. Section 4, my lord.
Jagged lands in relation to any office of village police means lands by whatever name described or locally known. Locally known, whether or not recorded as such.
Which
in
from your reading? Which section?
No, I'm
Section 4,
reading this one. Odisha Police. This.
Odisha Officers of Village Police Abolition Act.
Act 1964.
Jagged land definition. You are reading.
E. Clause E.
No. Where is the wasting?
Section 3, my lord. 3A, 1A. Is abolished. Thereafter, section 3 is the relevant provision, my lord. Is there anything in any other law, in any other rule or other custom, usage or practice having to force supply in any contract, some of the grant of in any judgment, decree or order of the court, with the effect from the appointed officers, the village police will deemed to have been abolished. The rights of the holder of office have been deemed to have been terminated. Or right to hold office and
vesting under the OPLE is also there. The definition of the land.
All rights related to obligations and all jagged lands shall stand resumed and vested absolutely in the state government, people all in the masters. Section 3
vested land.
Land belonging to or vested in any local authority, which is used or intended to be used for any public purpose such as road, canal, embankment, dam, property of this government.
So the difficulty is that whether this land comes within the purview of the OPLE Act.
Yes, but because it becomes a government land.
Show us that this is the government land.
Section 3E.
Please read.
Police Officer Abolition Act.
Please read.
But all jagged lands shall stand resumed and vested absolutely in the state government free from all income.
I am asking you an OPLE Act whether this land comes into that.
Yes, my lord. OPLE Act settlement can be done with the government land.
Show us from section 2. Which clause comes in your aid?
Section 2, election kindly change. Subject to the provisions of the OPLE Act, my lord. Subject to the provisions of any law for the timing in force, the following classes of land are hereby declared to be property of the government and purpose of the Act, namely public roads, streets, and all that, and rulers of the Indian state, India, of any ruler, Roman 1, of any ruler of Indian state, Maldiv state of Odisha.
That is not coming because that is the Act.
Yes.
It is a land held under that Act.
Under that Act.
Now, first one is not coming. Then
it is of the ruler because of the.
It is not coming under that.
Of any person,
It is also not coming.
A person holding in as the Rayatwari tenure.
It's not a Rayati.
No, there's
not a Rayati.
Having property right or any person holding land under the government authorized and of license.
That is also not a license under the government.
Land belonging to or vesting in any local authority which is used or intended.
This is what is only local authority which is used for any purpose. So
land acquired under the provisions of Land Acquisition Act.
It is also not that.
Land belonging to establishment or taking of
Yes.
any government, any state government or department of such government, any company in which lot is 15% of the share capital, corporation established a law.
So this Jagir land does not come under this vesting of a Jagir land does not come under purview of section 2.
Then they proceeding itself be bird ab initio.
Then how?
Proceeding itself be bird ab initio.
Which one?
The encroachment proceeding will be bird ab initio. So the Tahsildar, the encroachment proceeding initiated by the Tahsildar will be bird ab initio because he didn't have the authority. Actually,
that is what I'm inviting your attention.
So that part had not crossed my mind, my lord, but that part I would have otherwise I would.
If it is outside, then they will take recourse to any other act.
Any other act, my lord.
But you will not be able to claim that 30%, 30 years benefit.
No, that but the thing is that the just to proceeding will be. So, I was to get
the category of the land has.
Purview of regularship has to come within provision of section 2. Then the other proceedings should follow. That part, of course, I'm obliged with your lordship and I missed this point.
As far as they say.
I missed that point. That's
property.
I'll also examine on this issue.
First item.
No, the ruler is not there.
Of any ruler of Indian state merged with the state of Odisha, Zamindar, proprietor, sub-proprietor, landlord, Jagirdar, Kharposdar, or any other tenure holder, or any person claiming through or holding under any of them. This is under the OPLE. OPLE. Section 2, clause A1. Item 1. Subclub.
It is a land by a Jagirdar?
There's a chokidar jagir.
February 1964.
Don't get it. It will be available from my lordship's library also. I'll get it now. All the gazette notifications are available in your lordship's office. Lordship's library. You can get it now.
Section 4, are you saying? Section 4, are you saying?
Which one?
Of this village.
Oh, I'm looking at section 4.
Hmm.
I've seen them. That is what I'm saying.
So if this is Jagir land, then that is comprehended within the meaning of OPLE.
That is what I'm saying. That is outside the purview of OPM. Then what?
Now, OPLE refers to Jagir land. But
No,
that is a
not
different.
Jagir land.
Jagirdar.
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 But this is, who is the Jagirdar? Has not defined. That is why we have to know the concept behind it. Sorry, you bring that because we object, we do not know what is the nature of those land.
Yes, ma'am.
Actually, you are coming under this, and this is called a Jagir land. Then who has settled that land? From where that land came?
BPO proceeding, there is the thinking that call for that BPO proceeding record number of times, but and they have
No. Question which fell in my mind is that this is a very newer concept of a Jagir land.
Yes.
Now, this Jagir land, simply the definition is so ambiguous.
Yes.
I do not know that why this abolition act was invited. what was the scenario prior to this Abolition Act? How those lands were treated? Who has given those lands? Whose lands were taken by the British government or the East India Company, whatever? Because of my certain concept about the Khash Mahal land.
But these lands are either Jagirdars or the rulers. That is there in the village.
That is what there are certain lands like a Khash Mahal land.
It's an object of the act also I'll have to look at it.
That's why I'm saying. Are you aware of Khash Mahal land?
Yes, Khash Mahal
is different from a government land.
Yes, Khash Mahal is also available in Cuttack. Most of the lands are Khash Mahal land. Cuttack land.
So that is what it was. It was not owned by the British Empire.
No,
it is owned by the East India Company.
East India Company.
And
Cuttack was not owned
under the Government Grants Act, it is kept outside the purview thereof. Previously, Crown's Grant Act, now the Government Grant Act. But it is not kept within that purview. So it has a special category. Does it come within the purview of the government land? That is what is the main important. You come ready with this. It's an interesting legal point. I want to just.
Now, after judgment of this Honorable Court, now they are going to be evicted. Now, because they have already sounded that they are going to be evicted.
Come tomorrow. Give me that notification. Give me that.
After tomorrow.
Come tomorrow.
So tomorrow I'll get it, and day after tomorrow.
Day after tomorrow. Keep it.
Day after tomorrow.
Keep it for day after tomorrow as to be mentioned at the top. If necessary.
One is the revenue terminology. Let us see.
Here's the President Office for Nursery Finance. Nursery Finance, the running of Paradip Port, only major port of the state belongs. And it is running for last 12 days without secretary belongs.
It is running since last 12 days?
Without secretary belongs.
Without secretary?
Yes, belongs. And secretary is the head of the
assistant secretary is there.
No, he is not, because the secretary, his appointment is state. What has happened in this secretary also find? Because the appearance before your lordship Millers, he was appointed as secretary by the Union of Government of India, the Ministry of Shipping, Waterways and Transport Millers. Millers, by annexed to your lordship will find the appointment order. The appointment order is dated Millers 4/12/2025 Millers. Then in the very your lordship will find he joined Millers on the very next date, that is on 5/12. On the same day, on 4/12/2025, he joined Millers. And soon after joining Millers, your lordship will find, as per the convention, he has to issue circular, inform to all concerned that all correspondence whatsoever is to made to the secretary, and your lordship will find Annexure 3 dated 4/12/2025, the circular issued by the secretary. Then he started functioning Millers, and he has Millers signed so many Millers papers and also Millers questioning important things Millers. Then on
which order you are assailing?
Yes, I am assailing the order passed by the Honorable Single Judge Millers.
Which date?
That Millers order dated Millers 5th December 2025. Right, Annexure Millers. That's without writing opportunity, without
page 30.
Millers.
Page 30.
Page 30, exactly, page 30 Millers.
Page 30.
When the order of appointment has been acted upon.
Interim order you are challenging.
Sorry.
Interim order you are challenging. Interim order you are challenging.
Yes, Millers. And this interim order my lords knows.
This is absolute.
Here
No,
joined.
what a.
The person has joined there.
Yes, the joint started functioning.
This is operative till 17 tomorrow.
Tomorrow in the case, and in spite of Millers Paradip Port of the cabinet before the Honorable Single Judge. Because he brought to the notice of the Honorable Single Judge that in the meantime, already the appointee has.
Who are you?
Because I am for the appellant for Lordship.
That I know. Who are you?
I am the secretary.
You are a secretary.
Who is appointed by government
Who
of
is
India.
for the Paradip?
Correct.
And who is for the writ petitioner?
Writ petitioner, copy. I have given an advance copy to Mr. Samantrai, who is appearing.
You are appearing for whom?
I am for the Union of India.
My friend appearing for Union of India.
Union of India has passed this order.
The writ petitioner?
And the case is posted to tomorrow.
Yes, it's posted to tomorrow because the interim order has all trades and traffics by Lord's knows as a judgment. There is a judgment statement saying that if an order is passed, without granting opportunity to person whose interest is vitally affected, one. And number two, if the ultimate prayer that is going to be passed the writ petition is passed by an interim order. Because now what has happened? Because I am
What? Let me understand.
Yes, exactly. I know your lordship can smell and understand. I am equipped with a judgment, and so many other judgments are also there. And here
I have some judgments.
Correct, Millers.
I have some judgments contrary to those propositions.
I bring lordship very recent judgment.
Yes. Then in a suit for permanent injunction, there cannot be any interim order passed because it will tantamount to granting the final relief. Is it a correct proposition?
No, Honorable Supreme Court said, Millers, when an interim order is passed, because there are hundreds of judgments, interlocutory orders, Millers, are amenable to Millers letter.
This is what says that the interim orders are passed by the court in aid of the final relief and also to protect the parties to alter their position during the pendency of the proceeding. That is the main motive behind it. The interim order should be passed. It does not mean that final relief is won and therefore the interim order in aid of that cannot be passed. No.
But here what has happened?
Now, prior to passing of this order, interim order, pursuant to 1/12/2025, he joined. When?
I have joined on 4th of December.
He has joined and functioning. At that time, sort of.
I have started.
I also agreed as a graduator and
so what remains to be state, Millers? After the order of acted upon. Yes, I joined. I started functioning.
What happened? Let us see tomorrow what happened.
Tomorrow, Millers.
Because this order is operative till tomorrow. The main beneficiary of the order is not before us.
So, that your lordship can fix up tomorrow and matter can be decided here. Yes, sir. I have already given, therefore I have given the advance copy. The only question is, Millers.
Where is the writ petitioner?
Unless you are not direct to appear, Millers, sir. He may not, because I have given copy to him, Millers, but unless your lordship gives notice.
Whom you have given a copy?
I can take notice by Justice Millers.
Advocate for the petitioner.
Mr. Samantrai, reproduction Samantrai.
The appellant is directed to serve a note. So that's why I'm very cautious. What would happen day after tomorrow? Because this order will lose its force.
Question now,
after tomorrow. Now, if it is extended, the question is whether a appellant is required to challenge that extension order as well.
The whole question before lordship will be
Question is not. Question is of a procedure.
Procedure, Millers.
Because this appeal, whether it will become incompetent after tomorrow. Because this order is operative till tomorrow. Day after tomorrow, what will happen?
Your lordship.
It lapses.
If your lordship will not pass effective order tomorrow, my lords. Lords, then matter can be.
That is why we kept the matter tomorrow, give a notice here and now.
Okay. Deep.
If I
Plus.
My lord, I found, my lord, your lordship have dealt with all these issues.
Plus.
My lord, I found, my lord, your lordship have dealt with all these issues. And
Incorrectly.
No. So my case is virtually covered and nothing left to be disputed. Excepting, my lord, the one document which your lordship have not taken note of, which is there, my lord, that is at page 104. So I am saying, my lord, your lordship may kindly, since your lordship main issue has been decided, so let it be disposed of in the light of your lordship's judgment. Otherwise,
104, what does it say?
well, 104, you lordship may kindly see at page 104. Your lordship have dealt with another circular of 2014. 104 is the document by which the state government has declared
Equivalence
of this particular qualification in
Rashtrabhasha Shastri.
Yes, BA with Shastri.
This was not placed before us.
This
was not brought to our notice, otherwise I would have.
Yes.
Or rather we would have. This circular was not produced before us. So I didn't know. Otherwise I would have included.
Yes. So
He wanted that to be included so that in future he will say the covered judgment. He got his point.
Not that, my lord. This is the only the distinction I found out. This is by boundary.
No distinction. It's an additional fact in support of the argument.
Yes, additional point. But your lordship have dealt with the main issue, and my case is now
small one. Yeah. No, keep it for orders. Don't dispose it off. Keep it for orders. Or disposed of it.
चारी पेज 104 पेज सर कर दी था देखिए छोटे आप
Yes, for the next.
Just now they are served the copy of the report. Yesterday my direction just now served. Only to take a look. Just now served.
Next week. Next.
December. Right. Item 37. Item 57. My lord, it has not been served.
but our copy already served on serial. So Bharat, yes, sir. So far as the contesting respondent for whom my friend is appearing, Mr. Sahu. Today, I have served copy on Mr. Sahu. But so far as other seniors, some of them I have already served.
So far as I am the pro forma opposite party. Copy has not been served.
In this case, although they have served copy on me, I am for the respondent number 1, 2, 3, who is the lead person. Today they have served.
You are the only person. You are the real person.
Right.
Yes.
That
You
is
will
why
not hear others.
before looking.
Now, who's right to begin? It is whose right?
Appellant, state appellant. Here the state has filed this.
Yes,
Before that, I want
so
to
let them exhaust that right to begin under order 18 rule 1, I believe. Right to begin. So let them give.
But the core issue has already been answered in 2 writ appeals that I want to bring to your lordship's notice.
So that we can take a dissenting view and refer the matter to a larger bench.
So keeping in view, I am not saying so. You look into this for
Let him, sir. He is an appellant. Why you hijack his right to appeal, right to begin? Why you are hijacking?
Let them begin.
Yes. Yes, sir. Are you ready? Does not appear from your
gesture.
Body language. It does not appear. The way he is just turning the page, it appears that.
Next week.
So I anticipated that's why you are hijacking the issues unnecessarily. Yes. Then after vacation. Not before.
On Tuesday, January Tuesday. 6th month.
No, 6th, there are many matters. Then. Huh? So on a hearing day at 10th, is virtually a hearing matter.
Yes.
On 10th, then we are, sorry, on 10th, we are fixing.
No.
8th.
8th.
7th. Then we are fixing on 7th.
7th Wednesday. Yes.
Wednesday. Oh, it's not there. Actually, the May calendar is the January calendar of the next year. We look at the May calendar, it is a January calendar of the next.
May, set up May quarter. January. Yes.
Then it will come as a January.
Lordship, I treat my learned senior is how it's supposed to be. They pray for the salt at the and objection to it.
You are opposing?
I am opposing. And for the read petitioner.
You are opposing the prayer?
Yes.
He is not agreeing on an adjournment. He is opposing.
The matter will be taken up tomorrow. Lordship, I am not prepared. My learned senior is also out of station.
Tomorrow is not this.
Because the whole difficulty is that pursuant to the disciplinary proceeding, I have been compulsory retired from October 2023.
So what is the urgency now for you?
I'm out of job.
Maybe for 2023, he is asking for an adjournment. His senior is not.
Also, adjournment was granted because on the prayer made by the petitioner.
Then you can't. If you want to delay, who is the appellant?
Appellant is the university.
And there is no interim order.
No.
So why you are bothering?
They are not implementing the judgment.
But you know how to get the implementation done.
The direction was to reinstate me in service.
Oh, you know how to get the implementation
They are
done.
not implementing only on the ground that they have prepared a recap. That is also the communication.
An accommodation is sought on behalf of. Is there any proceeding pending?
No, my lord.
No, then we can't do it on behalf of the petitioner.
I could only sort me. Kindly understand, man.
You understand what is the best way of doing it. I am asking you what steps you have taken.
Initially, a content was filed. Direction was given to comply within a period.
Oh, that was a first contempt. Time to second contempt has not come.
It has arrived, but I have not filed because
Then the third contempt will be the last one.
Second contempt I have not filed because I have granted appearance in the rate appeal. For that reason, I have not filed. They are taking that way as just because.
Come on, 23rd, you'll have to argue.
23rd December. Always. Second 39th.
Family pension matrimonial. Initial 18.
No, what is the judgment? This is
Page 30.
Page 30 to 33.
What to do, madam? Is there any benevolent policy taken by the state
No, my lord.
in this situation?
No, my lord. There is no.
You ought to, you should. What is her fault?
Well, that's true.
But the difficulty is
South in the manner, my lord, and my lords are aware of.
what caused in the manner?
But there is a specific bar.
Madam, what can be done? Legally, what we can do for you? We wanted to extend some benefit, but
Service code.
if the law does not permit, then can we direct?
Already disclosed about the marriage before the.
Whatever be, but he has not changed. He has not changed any nomination.
After death of first wife, I am claiming, my lord, with this fact, my lord, which.
Can you claim it? I am just asking you, when the marriage itself is found to be invalid one, then can you claim?
Says wives, my lord, that is why I am claiming, my lord.
Now, under the General Clauses Act, the singular means a plural and plural means the singular both. It was extended to the first wife.
Yes.
So what remained?
When this first wife expired, the second wife will get entire.
Show us the rule. We are at one with you. Show us the rule that after the death of the first wife, second wife is entitled. I am ready to pass the order in your favor. Where is the rule? Show us. Which rule?
56, ma'am.
56 of?
56 of OC pension.
Where is that? Pension?
No. Pension rules. Odisha Civil Service pension rules.
Rule 56.
A.
Go ahead, please. 54. 55. 56.
6. Placement 56(6)(a) provides a manner.
So, madam, the note appended to the provision is clear.
Yes.
Is clear at when debarring you. What can be done? It's a note which is there. It says the second marriage is void and therefore not entitled.
Yes, ma'am. They have rejected my application on that, so which I.
So what is your, then what? They should be, show us the legal provision what to do.
Yes, my ground, I have taken ground that as the rule says, wife and wives and.
But the note is also appended, which controls the applicability of the section. That means they wanted to say the employee who married prior to the codification of the Hindu law, particularly the Hindu Marriage Act 1955, they are entitled. Or maybe a situation where Hindu Marriage Act does not apply.
Also taken the ground that as this is a general rule, my lord, that should not refer to the Hindu Marriage Act.
But the note has general rule means then the marriage is recognized under what law?
Please note should be taken into consideration where there is in the ambiguity, my lord. No one is challenged about my that first wife or anyone is not challenged my entitlement, my lord.
My judgment in another high court is against this proposition what you are proposing. I believe here also both of us has said that when in these kind of a rules or note is appended, what is the effect of those notes? It is a clarificatory in nature.
But it, my grounds is also there, the competent authority of the institution where the this is the civil servant has worked, my lord, he has submitted the pensions paper, they have made no objection to that also.
If a mistake is committed by somebody, does it become a law? Then this mistake should be perpetuated to be committed for all time to come. Tell us what is the law? Very difficult, man.
And family also described as their wives, my lord.
I understand, madam. There is no difficulty. There is a provision that the wives are entitled. But if the note clarifies that under what circumstances they are entitled, then in that event, can you ignore that? Wives, they wanted to give a clarification by virtue of a note means any marriage prior to 1955.
These rules come in 92 months.
So there may be a service holders who have married prior to 1955. Is a pension.
Yes.
So must have married prior to 1955, but is surviving, is still alive, or his wives are alive.
This rules should be retrospective. This rule should be.
So the marriage will also be given to a retrospective operation deemed to have been married prior to 1955. I do not know, madam, whether any retrospectivity can be attached to a marriage. No, brother, what can we do? We have also repeated our this white means there was no.
Skip for some other. Skip for some other. First wife was getting full picture. She had lived full life with the after this, we can't do that is not. Mr. Rath, can't you help?
Plus, here
You have tried or not
the
in such circumstances?
the children of the petitioner, they might have a claim on the pensioner. The petitioner may not have, being that marriage being
But the
null and void.
difficulty is because there are certain conditions attached to them.
Yes, Mullah, but there are judgments.
But those conditions are
That there are judgments.
to be fulfilled, but there is no condition attached to the wife.
Right, Mullah.
So automatically she's entitled to a pension. So have you thought of is nothing what we wanted. We do not want to interpret in a different manner, but
Plus, may grant one opportunity to get back on this, but I'll also try.
I know the difficulty is on your part also. And we have also percolated a difficulty on our part also.
The first one had no
issue.
children. So in that light, you try to.
The issues from the second wife, they may have a claim. I try to find out.
But she is alive. There is no dispute about that.
No.
And during the lifetime also, he disclosed in service book.
Yes, ma'am.
So,
recorded.
So in that perspective, we just think of the factual background. Strictly in accordance to law may not, but benevolence. You can have, the employer can have. So that perspective we ask patient to show your indulgence.
I will try to.
Otherwise, the survival may be.
Yes,
Evidence Act.
Let us examine this. Sir, the judgment, Pundalik Bhave. Mr. Sima Kohli has come. Let me read that.
What?
The question is, the Supreme Court of India recently delivered an important ruling in the case of so and so. The case revolved around a widow's claim for a family pension, raising significant legal questions regarding the validity of a second marriage during the subsistence of the first and presumption of marriage under Indian law.
It is proved that he has also admitted that he has signed the second wife. Anyhow, we'll see to it. Let us see if we can do something for.
Well, I'll also try to access my lots of this. There are some judgments of this court also. I'll find us.
Because under the Evidence Act also, there is a presumption of a due marriage. If a person is known to have resided together for a pretty long time as an husband and wife, then the question of legitimacy of the marriage is obliterated. It will be presumed that they are the husband and wife. If that being the presumption, then how can you?
Madam, can you please examine C. Ramabai, SHIRAMABAI versus the captain record officer, so and so, 2023, 11 SCR 130. The question was pensionary benefits, family pension, claim of by wife cohabiting as wife with a government personnel, denial of claim of family pension to the applicant and her children by the High Court, sustainability. It is answered in the negative, saying that maybe in your favor, I don't know. 52.
But it is, let us consider whether second or first.
And Evidence Act 114 is
that is what I'm saying, presumptive value of 140.
Supreme Court, that is 2023 INSC 744. The same equivalent.
No, it should be after vacation, but let us ponder upon it. We are fixing after vacation, let us ponder upon the things. Tomorrow is a hearing day. So keep the matter which has not been touched today for tomorrow first.
Only one.